I'm Ben Meiselas from Legal AF, joined by co-host Karen Friedman Agnifilo, taking a look at this motion that was just filed by one of Donald Trump's co-defendants in the federal case in the Southern District of Florida regarding the willful retention of national defense information, obstruction of justice, and making false statements. This is the case where Trump stole documents, classified information, top secret information, and concealed it at Mar-A-Lago, along with co-defendants Carlos de Oliveira, a maintenance worker who was added in the superseding indictment, as well as Waltine Nauta, Trump's valet and personal assistant who was in the original indictment. And so there's actually a huge breakthrough by Special Counsel Jack Smith that's kind of been buried in this defendant Carlos de Oliveira's opposition to the government's motion for a Garcia hearing. And you always talk about how in journalism, don't bury the lead. Well, where you're a criminal defense lawyer and there is a very bad fact for you, you probably learn the opposite, which is bury the lead right here. Because if you look at the very last sentence as they're talking about like what this opposition's all about, and Karen and I will just explain what a Garcia hearing, what this is even about. One of the key things that's mentioned are that critical witnesses who were formally represented by Carlos de Oliveira's lawyer, John Irving, in addition to the fact that Irving represents Carlos de Oliveira, they've gotten rid of John Irving as their lawyer, and they're represented by independent counsel. And that was one of the major concerns that Jack Smith had about not getting key information to prosecute Donald Trump. So we'll get there and let's break that down. But I didn't want to bury the lead in this video right here. So a Garcia hearing is where a prosecutor believes that that there is an unwaivable conflict of interest or just a significant conflict of interest where a defense attorney is representing a defendant or multiple defendants or a defendant and multiple witnesses all at the same time with adverse interests against each other, such that the client should be given appropriate information at a bare minimum threshold based on the conflict. The client should be advised about the conflict, their right to have an independent lawyer, and the fact that the representation could potentially have adverse impacts on them. And we've seen this throughout lots of these Trump cases because the Trump Political Action Organization is paying for the same lawyers to not just represent Trump and the co-defendants in the cases, but also witnesses. And we've seen, for example, in this case, where one of the witnesses, for the example, was being represented by another one of the lawyers being paid for by Trump's Political Action Committee. That witness actually lied before a grand jury back in March of 2023, then got independent counsel, and then told the truth that Donald Trump, Carlos de Oliveira, as well as the other co-defendant, Waltine Nauta, were involved in a conspiracy, telling this witness, now witness, who's not going to be charged, to destroy surveillance footage. Someone named Yusel Taveras. So, Karen, I found that very interesting here, where basically talk about burying the lead. One of the reasons why they're opposing the government's Garcia hearing motion is basically saying it's actually not really needed. They don't say it like this, but like it's not really needed anymore because the witnesses who we were representing, in addition to De Oliveira, now have independent counsel anyway, so a court doesn't need to appoint one. What'd you make of this motion?
So in New York, we call this a Curcio hearing, but it's down south. I guess it's a Garcia hearing, and or a Garcia motion. And I think that this motion, I agree with you. It's very interesting. They were basically trying to say it's the point is moot because he's no longer being represented. But I disagree with the attorney, John Irving here. I don't think in the same case, I don't think you should be allowed to represent a witness and then a defendant in the same case, and for just a practical reason. So, there's something called the attorney-client privilege, right? And the reason that exists is because it encourages people to speak, clients to speak to their attorneys openly and freely and share all their deepest, darkest secrets. And, that way the attorney can figure out the best way to represent the person, right? And so it's actually designed to encourage openness and honesty. And so clients will often share information that they hope never sees the light of day, could be incriminating, et cetera. And so that's a problem, right? Because as an attorney, you have that information, you have to keep it secret, and it's a privilege that belongs to the client, not to the attorney. And so you can never ever use it. You can never be forced to disclose it. And but there's a conflicting duty that all defense attorneys or all attorneys have, which is you have a duty to represent your client you have to give them the absolute best representation you possibly can. You have an ethical duty to do that. And otherwise they could argue ineffective assistance of counsel. So from a practical standpoint, how does it work if John Irving, speaking to one of these witnesses, one of these former clients who's now going to be a witness, and if past his prologue, the way Cassidy Hutchinson and other people will say, when I was represented by a Trump paid-for lawyer, I had to basically go with the program and give the same statement that, the Trump lawyer wanted me to give. But when I got my own lawyer, I could finally tell the truth. So John Irving is a Trump appointed lawyer. And so what if it turns out that like those other people, those other witnesses, same as you said, like Yuscil Taveras, right? Exactly the same thing. And what happens is, whatever these witnesses told John Irving when he was their lawyer, because they felt they had to. And why does Trump pay for these lawyers, by the way, for everybody? It's to make sure that I got you, this is expensive. Lawyers are expensive, and you'll lose your life savings because these aren't rich, wealthy people, right? These are janitors and IT tech people and maintenance people. I mean, this is not wealthy people. So I'll pay your lawyer so that you don't lose your house and your life savings, but you gotta stick with me, and you can't turn on me, right? So this is a way of keeping them under your thumb and making sure that they get with the program and they testify for you. That's why Donald Trump does it. So, but let's say we go to trial, and John Irving is Mr. De Oliveira's lawyer, and he all of a sudden one of his former clients gets up to testify and is a witness, and they testify truthfully. And the truth, however, is going to probably be different than what they told him when he was their lawyer, right? Because it's really it's Donald Trump's paid for lawyer. They can't tell the gang boss that I'm turning on the gang boss. It's terrifying, right? And so they're going to now tell the truth, which will be at odds with what they said before. And what's John Irving supposed to do about that? He can't cross-examine them and say, but didn't you tell me before something differently? Didn't you give a statement that was completely different than your testimony here that's under oath? He can't do that, right? He can't say that. And then, so how does he remedy it? He proposes, I'll tell you what, in this motion, he says, I'll tell you what, if they do testify, we have another lawyer here, local Florida counsel, he can cross-examine them. But you know what? I'm sorry, you're a defense team. You can't share with your co-counsel what you know. So how are you going to do? What are you going to do? Sit there and not give information that could help? You have a duty to help your client, even if it means cross-examining a witness, that you don't want to cross-examine with information that you have. You can't keep that in. So you have these conflicting duties, and it just logistically does not and cannot work. Even if he, has the other lawyer do it, he's still part of the legal team, and it just won't work. And so, I think the times when you can waive these conflicts in either a Curcio or Garcia hearing will be with co-defendants. If you have two defendants on the same side that both want to be represented by the same lawyer, but to represent a witness, maybe if you represented that witness in a prior case, that has nothing to do with this, maybe I could see that. But I still don't think there should ever be a time when witness or a person is cross-examined by someone who was their lawyer, who they told their deepest, darkest secrets to. That's just got to be horrible, intimidating, and put everyone in a very, very difficult position. So I don't think that this is a waivable conflict. The other thing that John Irving asked for is that this all happened. He said, look, you want to ask my client about whether he'll waive his Sixth Amendment right and waive any issue that he has with me representing him and that I represented these other people. Okay, we welcome, Judge. We welcome you to do it, but I want you to do it ex parte. There's no need for the government to be there. What does this have to do with the government? They don't need to hear what he has to say at this stage. This is an attorney-client thing, so I want this to be ex parte. The other thing he says is that if you're going to inquire, and there's no need to inquire the witnesses anymore because it's De Oliveira's Sixth Amendment right, not their Sixth Amendment right, and so there's, quote, no need to parade them in front of the press. So I thought that was interesting that he's still trying to protect his former clients by saying, oh, don't worry, you don't need to parade them in front of the press, and then only do the his client, now the defendant. But I think that he doesn't want to get off this case. He doesn't want the gravy train to stop. He's probably getting a lot of money here. But if it was any other normal judge and not Judge Cannon, I think they would say, no, this is an absolutely unwaivable conflict and I can't let you do this. But it's Judge Cannon, so who knows what she'll do, because she's clearly in Team Trump as well.
Oh my God, I couldn't agree more with you. But this could be we haven't had a situation yet, Karen, where there's actually been an appealable order to the 11th Circuit. There's been a lot of machinations and chicanery with the scheduling orders and things that Judge Cannon's doing, asking sua sponte the government to brief issues that Judge Cannon seems to be hearing about on Fox and other things like that. But we haven't got to really any decision yet that could be appealed. I think this could be one of the first ones. If there's an unwaivable conflict that the judge is ignoring or handling improperly, this could potentially be an issue that there's an interlocutory, expedited, CIPA-related appeal to the 11th Circuit. But if you break it down in very simplistic terms, Carlos de Oliveira is a maintenance worker, right, at Mar-A-Lago, who can't afford a lawyer on his own and may not know one could be appointed for him by a federal public defender. So Trump seizes on that disparity of money and as well as kind of just information and knowledge, brings this John Irving guy in to represent him, and hypothetically the situation's like, hey, we're going to protect you. We're going to take care of you. Here's, you don't have to remember a lot of things. Just we got your back, as long, with implicitly, if you're on Team Trump, we've got you back. We've got your back. And what we saw happen back in July with this Yusel Taveras witness, who would have otherwise have been charged the same way Carlos de Oliveira, there was a different judge in D.C., not because Cannon's in the Southern District of Florida, but a judge, Jeb Boasberg, did what he was supposed to do. Informed Yusel Taveras of his rights and what the situation was. Yusel Taveras then was able to speak with an independent lawyer and basically said, oh, I understand. That's why Trump's having a lawyer represent me. And it's not in my interest to continue to go down this path. I won't be charged if I tell the truth. And I think really what Jack Smith, we know with these three witnesses now, that they've left the representation of John Irving. But I think what Jack Smith really realizes, Waltine Nauta is going to be difficult because he's been with Trump for so long and literally carries, almost I'm making this up, but basically is feeding Donald Trump like cheesesteaks. He's with Donald Trump every second of the day. But there may be a difference, I think, here with Carlos de Oliveira, who maybe doesn't have that degree of kamikaze style loyalty to Donald Trump and is willing to recognize that there's an exit path by telling the truth here. So I think that's at play. And then, of course, the line by Irving, John Irving, saying to Judge Cannon, look, this whole issue is moot because they're no longer current clients of mine. But Karen, the issue still remains, of course, which is that, well, you've learned information from them now that you're going to cross-examine them with, and then you're going to say your co-counsel is going to do that. And what are you going to say? Well, when you were with me, you told me this. So you can imagine the situations where this conflict becomes really, really serious and, to your point, unwaivable. Make sure you all subscribe to Legal AF wherever audio podcasts are available, and check out MeidasTouch.com for all the latest breaking news. Have a good one.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.